there are 5 minutes. 5 minutes, and I hope the members will hold to that standard. I'll begin. And let me start with Captain Thomas. Thanks. Thanks for coming here. Thanks for more than 30 years of service in law enforcement. Thanks for more than 26 years of military service, including combat duty. It's an honor to have you as a panelist here, as it is with all of our panelists, but certainly I wanted to commend you for those things.
Thank you, sir.
You're probably aware of the fact that Judge Jackson has received the unqualified endorsement not only of your organization, Noble, but also of the Fraternal Order of Police and the International Association of Chiefs of Police, in addition to other law enforcement officials. Are you aware of that?
Yes, sir.
So there have been charges made yesterday, day before, even this morning, that she is somehow part of a, quote, anti-incarceration, anti-police movement, that somehow she is affiliated with a defund the police movement. Would you or your organization have endorsed her if that were true?
Sir, that would never happen if we knew that if she'd have made a statement like that. We never saw that in our research. That never came out. And I don't really think it's true, sir.
I don't either. And I would assume the same thing is the case for the Fraternal Order of Police, the largest organization representing rank and file policemen in America, and the International Association of Chiefs of Police, respected at their own level for the leadership they bring to law enforcement. So that is a charge which I think is belied by the fact that this endorsement has taken place.
Yes, sir.
Wade Henderson, you were in the audience. Welcome back. You were in the audience and heard the earlier testimony from the American Bar Association. 2 or 3, maybe 4 members have really dwelled on this whole question of sentencing in child pornography cases and child abuse cases. And I asked the 3 representatives of the American Bar Association if they had made inquiry among the professionals, prosecutors, defense lawyers, judges who have witnessed Judge Jackson's role in criminal justice, particularly in this particular area of the law. And they testified that they had consulted with 250 professionals to reach their conclusion of giving her a unanimously well-qualified rating. And I asked them during the course of this, since we spent so much time here with 3 or 4 members dwelling on that issue, whether they found any evidence to back up the charges that were being leveled at this committee level, and their answer was no. No evidence, not at all. You would think that one person out of 250 would have found the same conclusions as 3 or 4 of my colleagues did in the last several days. What is your conclusion from that?
Mr. Chairman, your questions to the American Bar Association representatives, in my view, were dispositive of this issue of whether Judge Jackson in some way was outside of the legal mainstream of other jurists or somehow tolerated the abuse of children implicitly by the questions that were posed. I thought their responses this morning were completely dispositive. I began, when I saw the testimony yesterday, thinking that, unfortunately, this hearing has devolved in some ways to a partisan attack on an otherwise extraordinarily well-qualified nominee. By any standard, Judge Jackson's record, both on and off the bench, her academic achievements are unparalleled with almost anyone who has been appointed to the Supreme Court. A failure to find her vulnerable on the basis of qualification has somehow led to a series of questions focused on 7 decisions that she rendered in sentencing that, in my view, bordered on the demagogic. I think when one takes a look at the repeated effort to pose questions about her record somehow being outside of the mainstream, indeed reinforced that view. Ultimately, I think the issue, as Senator Whitehouse mentioned, was both asked and answered, and that the judge had clearly demonstrated that she was well within the mainstream of judicial thinking. Finally, I felt that the criticism of some directed at her for her decision-making was misplaced, to the extent that her decisions, at least to those who questioned her, were somehow at variance with what the law was. They could have said that. No one did. But they could also recognize that it is up to Congress to establish the standards that judges apply in their decision-making responsibility. To the extent that there were questions posed about her, better to look inward at the role that Congress played in establishing the role that judges fulfilled in this moment.
Thank you, Mr. Henderson.